Whatever you might be going through and wherever you might be, this is Omar Serrano with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
Well, it's not after hours right now, is it? It's kind of like right in the middle of my workday, but here we are anyway. I was ready to break down this. There was something else I was going to do, but then this opposition came out and it was beautiful. I mean, I don't know if it was beautiful. It wasn't anything spectacular, but I would just say that if I had this opposition written about me based on something that I did, where half of the argument was, well, first of all, they cited unpublished law. Second of all, they got the law wrong. Third of all, I don't think that they even know what they're supposed to be arguing. I would feel really bad about myself as an attorney, and I feel like that's what Friedman has done with his opposition. I'm going to share it with you guys. It's not incredibly long. It is a 42 pages. It's really like a 30-page motion, really. The key arguments in the opposition, and this is in response to Ryan Reynolds. We're not getting in to the 47.1 stuff from Lively's much better written complaint, but problematic for Ryan Reynolds. As I was going through it the first time, I don't even know how long ago, it would have been like a couple of weeks ago. You go back and check the tape. I had made statements that when you call somebody a sexual predator, that goes above the scope of whatever opinions you might have. You can't just blurt out certain things and expect them not to be considered defamatory. In this context, and in the context I used in that other video, like a Nazi was one of them. Sexual predator is a pretty good one. There's literally sexual predator written into several criminal statutes in California. And I'd imagine nationwide as well. But you cannot just say something like that without implying prior knowledge of the facts. And then he went out of his way, Reynolds did, his attorneys did, to basically state that, well, I knew he was a sexual predator because of all of these other things that were not pled in the complaint. And Friedman, in his opposition, went so far to say that if you're going to rely on stuff that is outside of the four corners of the pleadings, then it's no longer a motion to dismiss. That's straight up a motion for summary judgment. And we should be able to write an opposition to a motion for summary judgment with a showing of evidence to the contrary. And what they've hinted at is, although discovery is not complete. What's up, Bruce? What's up, Rob and Ricardo and Redondo and all you folks? Mystery Singer, Mildly Mercurial. I like that name. Hey, guys, how much time is? We just got started. I've only been rattling on for about 3.5 minutes now. By the way, I'm very mindful. I just found out that Ask Two Lawyers is going to be streaming about this in about an hour. And so I'm going to try to wrap this up by then. I don't want to interfere with their time. And hey, I just found out that Ask Two Lawyers, their law office and my office is like 15 minutes from each other. So there's a real good chance in the near future that me and them may collaborate on a video about Lively or something else. I don't know. I've heard people call them or say that their show is kind of boring. I don't share that sentiment. I actually thought they're really informative. They're really good. Their analysis of this case has been spot on so far. I haven't really disagreed with them at any juncture, even with the 47-1 stuff. I thought that what they were saying is true. The biggest thing for Baldoni is that if he loses, the damages aspect of it is going to be problematical. And I agreed. So there was that. But hey, you never know. We'll see what happens with all of that. I haven't been in contact with them or anything, but they gave me a shout out on one of their last videos, and it was like, "Hey, we should do lunch together." Like, well, if you're just like right over there, maybe. You never know. So as far as this complaint, I didn't mean to do that. Before I get into this complaint, basically these are the arguments that Friedman is making. Defamation per se, you cannot call somebody a sexual predator in the context of how Ryan Reynolds did it without inferring that you had information to unknown facts that would lead the intended person that heard your statement to believe that something else was afoot. So in other words, I know he's a sexual predator. That infers that you have witnessed or had knowledge of predatory behavior. And who did he make those statements to? Well, people that would have had the ability to affect his career. And hence all of the other causes of action, that was one of them. Under California law, when you say somebody is a sexual predator, that is defamation per se. We got into this choice of law. I don't remember whether or not any of the contracts had subjected these parties to California law. But there has to have been something like that, because I keep on reading in the pleadings from Lively's side that, well, they agreed that California law would be the one. And so I don't know, but they were making other arguments that, look, just because the tort might have occurred in New York doesn't mean that's not dispositive that, oh, well, definitely New York law should apply. If the damages greatly affect things in California, then the test that the court uses means that, well, we should probably use California law then. And under California law, when you call somebody a sexual predator, that is called defamation per se, which means it's automatically harmful. You don't even have to plead special damages. It's a statement of fact. It's not an opinion. When you call somebody a Nazi, there's a whole history of bad vibes that go along with that term. You can't just call somebody that and expect people not to feel certain things. Some things that you call people, some words that you use, some things that you say, arise immediately within individuals, intense incendiary emotions that cause you to form opinions that might influence the way that you feel about certain things or people. It might specifically influence whether or not you work with that individual or not. And the claims have always been with Reynolds. I mean, he's going around talking to all these people that necessarily had the ability to affect Baldoni's career, but also had the ability to take the film from Baldoni and give it to the Lively camp. At least that's what they were trying to do. If you're doing all those things, it gives rise to all the other torts that we're talking about. Because it's defamation per se, we don't even have to prove financial loss because of the special rules that apply with stuff like that. And then, of course, they're saying that Reynolds obviously knew that this stuff wasn't true, that he was trying to take these very benign or banal occurrences that occurred and stretch them into sexual harassment, when we know by the way that Justin was interacting with Blake Lively, like if they're friends and they're talking that way to begin with, before she makes this 17-point list, and then you just somehow change the rules and say that, oh, I'm offended because you've come into my trailer upon my invitation and made eye contact with me, you're setting yourself up for a lot of things, and I'll get into that as I go through this complaint. It brings us to the civil extortion aspect of it, where in California law, you're allowed to sue people for extortion, and not just for money. You don't even have to claim that the person received money from the extortion. The threat of extorting or attempting to extort somebody for money or some other tangible assets would suffice. Here, the demand was for a false public confession under threat of reputational harm. And if that's not what extortion is, then I just misunderstand what it's supposed to be. You admit that I want you to give a public apology, or else the gloves are coming off. How is that not extortion? You don't need to actually get what you demanded in order for it to be actionable in the state of California. They talk about the false light. They're saying, obviously, if we're competing about whose law is going to control New York versus California, and New York does not recognize that tort, then obviously we're going to go by California law. It's a little bit different from defamation. It's specifically about misleading the public to see somebody in a false or defamatory way, hence calling somebody a sexual predator. California recognizes it as a valid privacy tort. And even if some of the facts are true, if you twist the narrative just enough, you can, in the state of California, find yourself guilty of that cause of action. They talked about some of the tortious interference stuff, that he got in the middle of business, and people seem to be less interested in those causes of action. But bottom line is, if he's guilty of defamation in the way that they've pled it, then he's going to be guilty of all of these other torts dealing with tortious interference as well. Prospective advantage, he costs us future deals, he's getting in the middle of our business, whatever. We're trying to make this movie, and they keep on interfering in such a way, and he's getting in the way or trying to make it so I can't make future deals in the industry. That's basically what the business torts are. And then they talk about the anti-SLAPP stuff. Reynolds is asking for attorney fees under both or either of New York or California's anti-SLAPP laws if it wins, but Friedman's like, hey, dipshit, this is federal court. And in federal court, you're not allowed to ask for those kinds of fees. Those are state-based shortcuts. The judge in this case has already ruled in a prior case that anti-SLAPP laws conflicted with federal rules like Rule 11, like Rule 52, I think it was. Reynolds didn't fight the right kind of legal claim to ask for anti-SLAPP laws anyway. So therefore, what we have here is a scathing opposition that, honestly, I think that Reynolds attorneys are going to read it and just feel bad about themselves. It sucks, but that's what it is. That's what it is. And so, excuse me, I forgot to make my tea, but I'm going to just have to muddle on. Let's get into some of this complaint before it gets too late. So this is the opposition. This is with respect to Wayfarer and basically all of the defendants. The main crux of this opposition is here. Their argument is First Amendment complaint gives adequate notice to Reynolds under Rule 8 that California law applies to the Wayfarer Parties claims, all 7 of them, against Reynolds, and that the First Amendment complaint states a claim for defamation. They're talking about defamation per se. They talk about they don't need to plead special damages because of defamation per se. They mention that Wayfarer Parties have adequately pled a claim for civil extortion, for false light and invasion of privacy. Those arguments, those supporting arguments, look almost identical to each other. There's some differences here. Then, of course, the business torts. They make the anti-SLAPP argument. Motion to strike should be denied, and then we're off. And so these are all of the cases that they've cited. And with that, we get into introductions. And they start with a quote from Ryan Reynolds. I realize that I'm too big to fail at this point, so I just crush my enemies and drink their blood. That was a direct quote from Ryan Reynolds on July 12th of 2024. And folks, if you might allow me to pause for just a minute as I get a cough drop here so I could continue and persist. I promise I'll be right back. I promise I will. Give me like 20 seconds. I don't know if that was 20 seconds or not, but I'm back anyway. All right, so here we go. So they start with this quote. And, people say a lot of stupid shit for a lot of reasons, but when you say, and you're recorded and quoted as saying, I realize I'm too big to fail at this point. I just crush my enemies and drink their blood. That's one thing, a hell of a thing to have recorded in a pleading in which you're being accused of doing exactly that. Reynolds pretends that the Wayfarer Party's First Amendment complaint fails to set forth any basis for his liability, that he merely acted as a supportive spouse. Not so. The FAC specifically alleges ample facts to support the Wayfarer Party's claims against him, based on both his direct actions and his liability as a co-conspirator. The motion fails to show the Wayfarer Parties fell short of their pleading under 12b6 and the Twombly-Iqbal standard. California law applies to each of the Wayfarer Parties' claims, but under the law of either New York or California, the Wayfarer Parties have pleaded defamation and tortious interference claims against Reynolds sufficient to defeat dismissal. I'll tell you, just spoiler alert, I don't think that Reynolds' motion is going to be denied outright. I think that in this motion, Friedman has basically alluded to and asked permission to amend his pleadings to state additional facts that have come to light, probably through discovery. So there's more coming. So they're not going to grant anything, but they're not dismissing it outright. They're going to say, all right, you want to amend your complaint? I'm going to give you an opportunity to amend the complaint. They'll give them 30 to 60 to 90 days to do that, or however long. I think it makes a lot of sense to go out to 90 days at least, to allow for the completion of some depositions and discovery or whatever, and then just come back and plead all that you got. And then what it's going to amount to anyway, even after all of that, is that these are all tribal issues, and I'm going to leave it up to the jury to decide. And that's where we're going to fall, but it's fun to read these things. So California law applies to each of. All right, so Reynolds, this is particularly true, whereas here, Reynolds had superior knowledge of the facts underlying the Wayfarer Parties' claims, given the early stage of discovery. So they're saying the Wayfarer Parties have pleaded defamation and tortious interference claims against Reynolds sufficient to defeat dismissal. Particularly true, Reynolds has superior knowledge of the facts underlying the Wayfarer Parties' claims given the early stage of discovery. And in the alternative, any defects of inartful pleading are easily curable. My voice is going, man. The FAC can be remedied by amendment, which is freely allowed, and the Wayfarer Parties have gained additional information to plead further facts to support each of their claims against Reynolds, as well as the need to apply California law. Furthermore, that's going to be related to damages and all of the effects of the new things that they've discovered. So what they're saying is, look, we didn't have all the information when we wrote our initial complaint. We still didn't have it when we filed our first amended complaint, but we have some extra stuff now. And oh man, if you gave us an opportunity to amend it, and we might just ask to do it anyway outside of this motion, there's going to be additional facts. Furthermore, the Wayfarer Parties can amend their complaint to more fully incorporate the allegations of Exhibit A into the body of the complaint, mooting the motion to strike. And finally, even in the extremely unlikely event that the court determines dismissal without leave to amend is appropriate, Reynolds is unable to recover his attorney fees, as neither California nor New York's anti-SLAPP laws apply here in a federal case. So, in short, motion should be denied. Legal standard in the background, nobody cares. I think we all know what it is. Arguments. The First Amendment complaint gives adequate notice to Reynolds under Rule 8. Reynolds incorporates by reference the arguments made by other parties that the FAC contains impermissible group pleading. You already said that. He's incorporating all the other stuff. The Wayfarer Parties incorporate their responsive arguments from their oppositions to the motions to dismiss of the Sloan Parties in the New York Times and reiterate that any defect can easily be cured by amendments. so they don't have to restate everything word for word here. Just reference, it's all the same shit. California law applies to the Wayfarer Parties' claims against Reynolds. The choice of law rules of New York, the forum state, apply. The first step is to determine whether the laws of New York and California conflict. Spoiler alert, of course they do. An actual conflict exists where the applicable law from each jurisdiction provides differing rules that have the potential to affect the outcome of the case significantly, and where one state recognizes a cause of action and the other doesn't, that's a pretty obvious conflict. The laws of New York and California conflict as to each of the Wayfarer Parties' claims against Reynolds for defamation, false light, invasion of privacy, tortious interference, civil extortion. As to false light and civil extortion, the conflict between the two states' laws is total. California recognizes the claims and New York doesn't. The false light claim, like libel, exposes a person to hatred, contempt, ridicule, or obloquy. Honestly, I'm not even sure how you pronounce that word. I hate that word, obloquy. New York State, or New York, does not recognize the tort of false light, invasion of privacy. They kind of write it off as kind of the same thing as defamation, but there's a big distinction in California, and such that, yeah, you can still be defamatory. You can still try to portray somebody in a false light without being defamatory, which is basically the subtle distinction. They just give examples here. Extortion and attempted extortion do not imply a private right of action. California's law recognized civil extortion and such. This head note was interesting. The claim for false light, invasion of privacy is personal to and brought by only Baldoni, not the other parties, Heath, Nathan, Abel, Sarowitz, Wayfarer Studios. It ends with us, all of them. For simplicity's sake, this opposition refers to the claims collectively as being brought by the Wayfarer Parties. The laws of New York and California also conflict with respect to defamation. California extends no greater protection to opinions than does the United States Constitution. New York expands it. By contrast, in excess of the United States Constitution, provides for absolute protection of opinions, meaning it's a little bit harder to prevail in New York than it is California. As New York and California laws conflict, the court must determine which law to apply to each claim. Under New York's choice of law rules in defamation cases, the state of the plaintiff's domicile usually has the most significant relationship to the case, but that's not dispositive of the case. Although the preference for the plaintiff's domicile is not conclusive, the significant contexts in a defamation case are almost exclusively the parties' domiciles and the locus of the torts. The interest of a state in a defamation action is significant and uncontrovertible, where the plaintiffs are citizens of that state and live in another. Though New York may have some interest in this action because Reynolds resides in New York, California has a much more significant interest because nearly all of the plaintiffs are residents of California or have their principal place of business there. The two corporate plaintiffs, Wayfarer and Ends With Us, are both incorporated and or have their principal place of business in California. The plaintiffs suffered injury to their reputations in California, and the economic losses to the plaintiffs were felt in California. That's honestly, I don't know how the judge is going to rule on that, but it makes a lot of sense. I feel like they're going to apply California law, don't get me wrong, but as to this specific argument, who suffered the greater harm, California or New York, it's arguable whether or not, because you can make these same statements about New York as they're making right now about California, is all I'm saying. In addition, the underlying New York Times article, which is in many respects the genesis of this entire action, is purportedly based on reporting relating to Lively's complaint filed with the CRD, which asserts claims for violation of California law. Yeah, but you just said that that's not dispositive, is it? Well, he said the domicile, to be fair, I guess. But yeah, good arguments. I think California law is going to apply. It makes too much sense for it not to. The FAC states a claim for defamation against Reynolds, where defamation is clear on its face. It is defamation per se. So this is, now we're getting to the meat of it. And when I was reading Reynolds' motion to dismiss, his 12b6, my biggest criticism of him was, you can't just say it's your opinion that he's a sexual predator. And then they went in to like argue all this stuff. He admitted as such way back like 20 years ago. He said that when he was a teenager, he there was consent things, and he went on a podcast saying that he was an unevolved man and he did terrible things to women. Therefore, through my great disdain for him and having firsthand knowledge of those things, I labeled him, in my opinion, a sexual predator. You can't just effing say that, though. You can't just say that. Like, I mean, you could say it's like your mom. I guess you could go and say that's like your friends, but what if your mom and those friends happen to be responsible for employing or not employing Justin Baldoni in future endeavors? That's problematical, isn't it? It's a suggestion that you're not just saying that because it's your opinion. You're saying that for a purpose. Like, he didn't just say that to friends that have nothing to do with this movie. He said this specifically to key players that were responsible for employment decisions going forward, not just with this movie, but in the future. One would argue that, if anything, it's a lot of things, but what it might also imply is that that is evidence of malice. Not just negligent disregard for the truth. That's straight up effing malice. And that's how we get into all the other causes of action. Anyway, to get into it. It is defamation per se, damage is presumed. To plead defamation, a plaintiff must allege a written or oral defamatory statement of fact concerning the plaintiff, publication to a third party, fault, either negligence or actual malice, depending on the status of the libeled party, falsity of the defamatory statement, and special damages or per se actionability. At the pleading stage, falsity of the alleged statements is presumed. The court must decide only whether the statements alleged to have caused plaintiff injury are reasonably susceptible to the defamatory meaning imputed to them. In other words, all the court has to decide is, if you call somebody a sexual predator, is it reasonable to think that an average person is going to attribute to that person that was called a sexual predator terrible things? And that's reasonable. It's reasonable. We're presuming that it's not true. And in that presumption that it's not true, if I just label somebody like, okay, you're going out and before you just make a decision to hire an actor for a movie, you go up to their boss and say, hey, just so you know, I think you should know this guy's an effing sexual predator, man. He's so bad. His behavior is so inappropriate. If it's reasonable that that employer would, from that adjective, take away that the prospective employee, let's just say Justin Baldoni, has done some bad things, then it's going to go forward. That's all the court has to decide. That's it. Then they say the FAC sufficiently identifies Reynolds' statements, defamatory statements of and concerning Baldoni and other way. I hate this shit. This stuff bothers me, man. Like, put this on the next page. I hate when it's cut off like that. Anyway, that was my nerdy little lawyer peccadillo. Reynolds' contention that the FAC fails to identify defamatory statements he made fails on its face. Federal rules require each pleading be specific enough to afford the defendant sufficient notice of the communications complained of to enable him to defend himself. Reynolds must have confused the rules of pleading. This is where they start talking a little bit of shit. Reynolds must have confused the rules of pleadings with the rules of evidence. And then they cite this case distinguishing the standard to plead defamation from what a plaintiff must prove at trial. In other words, pleading's way more lenient. And I don't think that they have the ability to differentiate between the two. They cited you a case that deals with what happens at trial. But this is just pleadings. I think they got confused. It's such a dick thing to say. They asked for it, I guess. Less particularity is required in the allegations of the complaint where the adverse party has a knowledge of the facts superior to the party pleading them. The FAC alleges that at least twice, Reynolds stated to the WME execs, employers, Baldonis and Wayfarer's talent agency, that Baldoni's a sexual predator and that by implication, WME was in business with a sexual predator. When you say that to somebody's employer, I could not make an argument that that is not defamation per se. And with that respect, I kind of see the task that was ahead of Reynolds' attorneys when they wrote their 12b6 motion. They had to somehow argue that that was not defamatory. How do you do that when you're saying it to his employers? Not only is it per se defamatory, but that's almost per se malicious. It's his employers. It's not some girl he wants to date. The first statement was on July 15, 2024, when Reynolds contacted Baldoni's agent, Danny Greenberg, for the purpose of making these defamatory statements. On the call, Reynolds referred to Baldoni as a deranged predator and warned Greenberg that Baldoni should not attend the film's premiere the next month because no one wants him there. By the way, even if they have additional facts to support all of these things, they can't really plead them here in this opposition because they have to kind of stick to the four corners of the pleadings. If they try to go outside of the pleadings, then that's just saying, okay, well, I guess you're just going to have to amend your complaint then and put them in that one. So that's why you're going to hear them reference a lot that, look, I can amend it if you want me to. All I'm saying, if you find deficiencies, I think it was sufficiently pled. If you find deficiencies, I could easily cure this. So just give me the word, Your Honor, and it will be done. The second statement was, did I miss something? Yeah, deranged predator, deranged. Warned Greenberg that Baldoni should not attend the film's premiere the next month because no one wants him there. The second statement was on July 22nd, 2024 at the Deadpool and Wolverine premiere when Reynolds told a senior WME exec that by representing Baldoni, WME was doing business with a sexual predator. As alleged, Reynolds was pressuring and later demanded that WME cut ties with Baldoni. Those allegations are more than sufficiently specific, identifying the speaker, the listeners, and why, where, when the statements were made. Given the specificity, it is unclear why Reynolds cites cases involving allegations so threadbare as to omit the time, place, speaker, or listener. And so the examples, he's talking shit about their examples now. And their examples were essentially not really the same context of all of this stuff. Let me get to some of your guys' super chats before I move on to another page. Ricardo with the 2. I wish I knew how Lyman sees all of this. I could pretty much guarantee you that Lyman sees this. I mean, Lyman already knows how he's going to rule with this. I think he's already kind of hinted at the one hearing that we read through the transcripts that, look, these are allegations. These are triable issues of facts. He's already identified as like 90% of this case is triable issues of fact. And so he's already of the mind, I think, that he's not dismissing anything. I think he recognizes, as he alluded to at the last hearing, that I know that you guys are doing a lot of this stuff for PR, but knock it off with all of that. Sort of. I mean, he kind of sort of said that. I don't think that he's necessarily pissed at anybody for what's going on because this is pretty common fare, but I think that he kind of has a pretty good idea that he's going to ask the Wayfarer Parties to amend their complaint and add additional facts. And there's going to be specific directives on how to do that when he holds the hearing on this motion. The Crow is a new member. Hey, Crow. Crow is also an old member. I thought she was a member before. How you doing, Crow? It's good to see you, man. Ricardo, again, also became a member. Is that a picture of you, sir? If so, I'm jealous of your beard. Truly, and surely. The Crow with 5 says, love the new way of presenting this and so much easier to understand. I don't know if this is a new way that I presented this. Is it just like the highlighting and stuff that or highlighted specific portions of it. Well, it helps me read it better too. That's kind of how I read legal documents in my own practice. It's good to separate things. Helps you find it fast when you're in front of the judge. So Friedman criticizes Reynolds' use of these stupid cases. I don't understand why Reynolds is using these cases involving allegations so threadbare so as to omit time, place, speaker, listener. As to the other Wayfarer Parties, the FAC alleges that Reynolds worked in concert with Lively, Sloan to publish and falsely smear them. Reynolds and his co-conspirators made statements to third parties, including at least to the New York Times, that the Wayfarer Parties engaged in permitted and or failed to prevent sexual misconduct toward Lively and retaliated against her for reporting the alleged misconduct, including by spreading lies to damage Lively's image. Reynolds with Lively and the Sloan parties told the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints, knowing that the newspaper would publish them. A statement underlying a defamatory claim must specifically refer to or be of and concerning the plaintiff. And they give examples of these cases. There is no question that requirement is satisfied. As alleged, all the Wayfarer Parties have become figures of infamy because of Reynolds' statements, which were widely disseminated, understood to refer to them. Furthermore, the of and concerning requirement is an issue of fact for the jury to decide, which means this is not getting dismissed, no matter what Lyman thinks about the veracity of the claims. The court may dismiss an action only where the statement is incapable of supporting a jury finding that it refers to the plaintiff. This is not a case in which a jury would be incapable of finding that the statements at issue refer to each of the Wayfarer Parties. So that minor exception does not apply. Any doubts raise a question for the jury, not a question of law for the courts and stuff. All right, so Wayfarer Parties allegations also implicate a small group exception. The group defamation doctrine. An individual belonging to a small group may maintain an action for individual injury resulting from a defamatory comment about the group. In other words, it's one thing to say, oh, I'm an employee of the United States Postal Office. Well, sir, the United States Postal Office employs like over 1 million people. A defamatory statement against the USPS does not individually implicate anybody. But a group of 7, the Wayfarer Parties, you implicate one, you necessarily implicate them all, is the theory behind that doctrine. Here, there are 7 Wayfarer Parties, well below the ceiling of the small group exception, and Ryan's defamed them all. Defamatory statements are not actionable opinion. So under California law, to constitute defamation, the offensive publication must state facts rather than opinion. A statement is defamatory only if capable of being proved true or false. Statements do not imply a provably false factual assertion, and thus cannot form the basis of a defamation action if they cannot reasonably be interpreted as stating actual facts about an individual. And there's a million examples that we went through. You say somebody's crazy. I mean, that's an opinion statement. I have no reason to believe that that was like a statement of fact. Unless you take it further. No, he's crazy because like he 100% has been diagnosed. He's on medication. Now, if those are false statements, then his opinion that he is on medication would not be protected. Those are defamatory statements. Recklessly pled and all that kind of stuff, whatever. But a statement of opinion is actionable, and this is really important. A statement of opinion is actionable if implicitly based on undisclosed facts, and this is the key. This is why it makes it defamation per se. When you say sexual predator, it presupposes that you have information that would lead you to conclude that. Whether the statement is fact or opinion is for the jury to weigh. Here the question is whether a fact finder could conclude the published statements imply a provably false fact. The court applies a totality of circumstances test in which the court reviews the language of the statement and the context in which the statement was made. If a statement is factually specific, earnest, or serious in tone, or the speaker represents himself as unbiased, having specialized or firsthand experience, or having personally witnessed abhorrent behavior, this may signal that there is a factual basis for the allegations. I don't know what you call him a sexual predator for. He must know something. I don't know what he knows, but he knows something. Something bad happened. Courts applying New York law generally consider whether specific language in the issue has a precise meaning, which is readily understood, whether statements are capable of being proven true, and whether the full context of the communication in which this statement appears, such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. Whether statements are capable of being true. Is it true, or is being labeled a sexual predator, that particular adjective, capable of being disproven false? I think it is. The question is whether in full context of the communication in which the statement appears, such as to signal readers or listeners that what is being read or heard is likely to be opinion or not fact. That's a big one, because when somebody says sexual predator, in your own lives, I have people sit in my office all the time. One of the adjectives that has lost meaning for me is narcissist. 98% of my clients that walk into my office are dealing with a narcissist in their life. So they say. So they label everybody that. It doesn't mean much. It's like, okay, so where did you get that from? But when they call them an abuser, when they call them a sexual predator, when they call them, when they say that they've been the victim of domestic violence, that is a specifically different meaning. I can prove or disprove those things based on the evidence. And it leads me to believe in the chair that I sit, that the person must have some kind of underlying knowledge that would cause them to believe that. And that's kind of what the court is saying. We look at everything in context. New York courts focus on the overall context, which the complaint of assertions were made. Context includes not only the immediate context in which the disputed words appear, but also the larger context in which the statements were published. If a statement contains opinion, the court must then examine whether the statement is pure opinion, and thus non-actionable, or mixed opinion, and therefore actionable. The actionable element of a mixed opinion is the implication that the speaker knows certain facts unknown to his audience, which support his opinion and are detrimental to the person about whom he is speaking. In other words, Ryan Reynolds is in a lot of trouble. This is going to go to a jury trial. I don't know if they're going to settle this or not. I don't know. I'm still of the opinion that at some point they must settle this, but I don't know who's pushing for the settlement. I don't know if Friedman is entertaining settlement offers at this point. I don't know if Lively has authorized her attorneys to start talking about settlement. I don't know if those discussions, of course, those discussions have been had, but I just don't see the way that this evidence is coming out, that Friedman is going to put in all this work and not at the very least want to put Ryan Reynolds' ass on the stand and confront him about these statements. I think there's a really large part of Friedman that wants to do this. Number one, it's substantially more in attorney fees. Number two, I think he really loves this shit, man. And number three, I really love Friedman's style. I really love the way that he just goes in and he attacks. He waits for you to make mistakes and then he attacks. And he's not afraid to put stuff out there. He doesn't just put stuff out there for the sake of putting it out there for PR. I know he did the timeline, but that timeline was effective because it was based on fact and he had it. It was in his back pocket as a weapon. And so F it. We're just going to drop an atom bomb right now. And since he published that timeline, Lively and their legal team and Reynolds and all the rest of them have been on their heels throughout this litigation, really since like January. It's been a striking thing to say, a masterclass in PR for sure. But I like Friedman's style. I like the way that he's litigating this. Continuing with this, Reynolds' attempt to recast his statements as opinion is belied by context. These statements were statements that at least implied undisclosed facts. All are susceptible to a defamatory meaning, namely that Baldoni has committed egregious sexual offenses that warrant the label of sexual predator. That's kind of the obvious takeaway from it, isn't it? He continues on. He cites some case law, and context also matters. Reynolds made these statements to key WME figures in an effort to force WME to drop Justin. Reynolds' argument that his deep disdain for Baldoni precludes a defamatory meaning to his words is illogical. Illogical. He admitted in the pleadings that he has a deep disdain for Justin Baldoni, and then tries to make the argument that that's somehow exculpatory of these defamatory statements, when Friedman is saying, actually, I kind of feel like that's more inculpating your guilt to all of this, supporting that you made these defamatory statements with malice. I cited this stuff in the footnotes. The question before the court was not whether the use of he's talking about the stupid cases that they had quoted in there, 12b6, Wexler versus Legion. Question before the court was not whether the use of the term predator was actionable opinion, but whether it accurately characterized the allegations in the lawsuit for the purposes of the fair reporting privilege. Doesn't really fit our case. They talk about the statements at issue describe the plaintiff as a predator, the face of evil, which is not true here given Reynolds' deliberate use of the modifier sexual. The narrow set of events Reynolds purported to be referring to and his target audience, this other case he talks about, which is unpublished. If you're a young attorney out there, if you're a law student and you're listening to this, don't do this shit. There was no reason to use an unpublished case in this 12b6. There's dozens of cases that were on point that were talking about what this unpublished case talked about. Why would you use an unpublished, non-citable case? Why? It makes you look like a dumbass. I've seen other attorneys do it. I know why people do it. I know there's a limited purpose for why you would do that, because you're trying to be persuasive, but it doesn't hold any authority. So when you do stuff like that, it opens you up for the other side to call you a dumbass, as Friedman is kind of doing right here. Unpublished, non-citable under California law similarly involve the use of hyperbole, which in context clearly was intended as opinion rather than facts. This is altogether different than telling Baldoni's talent agency that Baldoni is a sexual predator. You guys get the point. To finish his sentence, that deep disdain, which Reynolds seems to view as exculpatory, supports an inference of actual malice. Continuing on, Reynolds argues the defamation claims fail because his alleged statements are substantially true. But truth is a question for the jury. There are some exceptions. The only exception when substantial truth is evident to the court. It's not the case here. We don't know for certain that anybody is anything or that anybody is not anything. So the exception doesn't apply. And if they're going to argue that it was a true statement, that is a question for the jury to decide. Inappropriate to argue that in a 12b6. That's the takeaway. Court cannot conclude as a matter of law that Baldoni is a sexual predator. The Wayfarer Parties smeared Lively to retaliate for her disclosure of supposed misconduct. These propositions are expressly denied in the FAC with proof. Therefore, triable issues with proof. Reynolds' statements have a different effect on the mind of the reader or listener from that which the pleaded truth would have been produced. Reynolds first argues that the First Amendment complaint alleges facts that a reasonable observer could well consider predatory. He next argues that a review of extrinsic evidence specifically Baldoni's book, podcast. This is a crucial portion of this opposition right here. He's arguing that when he decided to bring in facts that were not in his pleading, that were not in the pleadings, then that kind of basically turns his motion to dismiss into a motion for summary judgment, which would require altogether a separate kind of response, full of evidence and things for the judge to decide. Reynolds points to, before I get ahead of myself, so he argues specifically, he talks about Baldoni's book, podcast, YouTube appearances. Those are factual bases for his assertion. His first attempt collapses upon any scrutiny of the FAC. Reynolds points to, and then we go over it again, conversation Baldoni had with Lively at Sony's direction about her wardrobe choices, a suggestion from the film's intimacy coordinator relayed to Lively by Baldoni, as Lively would not meet her about the mechanics of a particular intimate scene, calling a costume sexy, the onesie, hiring a Shakespearean-trained actor with an MFA in acting to play a doctor, the birth scene. He hired one of his friends to get close to my vagina. That was literally the claim. It's like, what? Lady, he is a Shakespearean-trained actor. Who would you have preferred to be in that position, if not him? Jamie Heath, not Baldoni, showing Lively in preparation for a birth scene a single clip from a home birth video depicting Heath's newborn son, and Baldoni's purported failure to deny biting and sucking on Lively's lip, even construed in the most uncharitable lights, which would be inappropriate here. These admissions do not show Baldoni as a sexual predator. Reynolds' second argument is barred because it would require the court to consider extrinsic evidence not properly before it on a Rule 12b6 motion, and that would turn it into a motion for summary judgment. To prove that Baldoni is a sexual predator, Reynolds draws on excerpts from Baldoni's book, YouTube videos, a podcast episode, none of which are in the FAC. Reynolds' statements to WME execs did not refer to Baldoni's, that's an important fact, did not refer to Baldoni's past statements. As alleged in the FAC, Reynolds was referring to what purportedly happened on the set of It Ends With Us. Reynolds' continued effort to smear Baldoni is irrelevant, given that the submission of evidence is not proper in a motion to dismiss, because it is only the sufficiency of the pleadings that are at issue. Dipshits. What were you doing? On a 12v6 motion, if matters outside the pleadings are presented to and not excluded by the court, the motion must be treated as one for summary judgment under Rule 56. All parties must be given a reasonable opportunity to present all the material that is pertinent to the motion. There are few narrow exceptions, including for written instruments attached as exhibits to a pleading. Courts will sometimes consider documents that a plaintiff had either in its possession or had knowledge of and upon which they relied on in bringing suits that were integral to its complaint, but the extrinsic evidence Reynolds relies on was not incorporated into the FAC or integral to it. The defamation claim against Reynolds has nothing to do with Baldoni's book or the other extrinsic materials Reynolds raises. Reynolds' request is thus distinct from submissions by past defamation defendants of the defamatory material, even when such materials were not directly incorporated into the pleadings. The FAC does not rely heavily upon the terms and effect of the material submitted by Reynolds. Here, the court may exclude the additional material and decide the motion on the complaint alone, or it may convert the motion to one for summary judgment under Rule 56. In other words, either deny his motion or turn it into a motion for summary judgment so we can properly defend ourselves. All right. The Wayfarer Parties need not plead special damages because defamatory per se statements are implied to incur damages. And there's not much addition that we haven't already spoken about here, but I'll go over it just in brief. Plaintiffs need not plead such damages where the statements are defamatory per se. I swear to God, I can't talk. It's only Wednesday and I can't talk already. With such statements, damage to plaintiff's reputation is conclusively presumed, and he need not introduce any evidence of actual damages. I'm going to gloss over that. I highlighted this. The statement is actionable without alleging special damages if it tends to expose the plaintiff to public contempt, ridicule, aversion, disgrace, induce an evil opinion of him in the minds of right-thinking persons, and to deprive him of their friendly intercourse in society. I just underlined that, honestly, because it was so beautifully written. And I remarked that case is almost 100 years old. 1926. As to slander, New York law recognizes 4 statement categories as per se actionable, including those charging plaintiff with a serious crime and that tend to injure another in his or her trade, business, or profession. As to the statements concerning Baldoni being a sexual predator, there is no question these are defamatory per se. Perhaps the clearest example of libel per se is an accusation of crime. I swear to God, I said that 3 or 4 weeks ago. Reynolds' statements about Baldoni being a sexual predator is tantamount to a charge of serious criminality. Turns out that there was a case where they say that when you borderline label somebody a criminal, that's an example of defamation per se. That is a California case from 1986. Reynolds' statements about the other Wayfarer parties are also defamatory per se. The crux of the accusations is that the Wayfarer parties engaged in and or condoned sexual misconduct and took revenge on the victim of such misconduct. These allegations tend to expose the Wayfarer parties to public contempt, ridicule, aversion, disgrace, all these other things. I think I skip over that. Wayfarer parties have pled actual malice. I think they really have, especially with respect to Ryan Reynolds. With respect to Lively, that argument is going to be a little bit harder unless you could tie her into the conspiracy. And by the way, there's this Redditor that has been in contact with me that has taken a really intelligent approach to investigating the claims in these pleadings. What she's basically done is taking all of the text messages contained in the pleadings, put them in chronological order, and just kind of point out where specific things happened, trying to tie it into a claim of conspiracy. And to be honest with you, her investigation, I mean, it's wrong in a lot of parts, and I'll go over it probably not in this video, but later tonight or maybe tomorrow. But it fits, I think, what Friedman is preparing to argue about how they're going to get around the conspiracy issue by clear and convincing evidence. I'll go over that. That's for another video. It's not for this one. I'm going to finish this. The actual malice one, especially as to Reynolds, is going to be easy. Not easy, but it's a lot easier to see than with others. Under the Constitution, a public figure pleading defamation was proved by clear and convincing evidence that it was made with actual malice. Reynolds was intimately involved in and integral to Lively's concerted campaign of extortion to extract concessions, creative control over the film. Reynolds and Lively exploited Lively's false insinuations to coerce the Wayfarer parties to cede to them power and authority. Power is an asset. Authority is an asset to which they were not entitled. Reynolds was also directly involved in the marginalization of Baldoni from the rest of the cast and exclusion from the premiere. Having yielded under duress to their coercion, Wayfarer finally resisted the Lively Reynolds demand that they take the fall for Lively's disastrous promotional campaign. And then Reynolds and Lively pushed falsehoods from production with a lie combined with an untraceable smear campaign to the New York times. Reynolds and Lively, along with the Sloan parties, engage in a coordinated effort to exaggerate benign interactions in service of a false narrative that Lively had been sexually harassed. All this is so important because taken together, all of these threads together form the rope to Malice. They did so to instill terror in the Wayfarer parties and leverage it to accumulate power. Power that could be converted to future riches. And that's why the California false light cause of action is so important. I mean, among other things. This accumulation of power depended upon the ability to conjure and exploit ruinous allegations. The allegations were never true, and Reynolds knew full well, or did not care, whether they were true. Reynolds' insistence he believed his words, although not alleged in the FAC and thus not properly before the court, is an argument that he committed extortion, not defamation. And there's a footnote to that. Again, Reynolds' deep disdain for Baldoni does not imply he did not act with actual malice, even if the allegations of ill will are insufficient to raise the inference. Evidence of Reynolds' ill will is probative of his mindset. Probative means it's illustrative of what he was thinking at the time he made those allegations, performed those actions. What was his motive? What was his purpose? Well, it seems like they were malicious, because let's just connect all of the dots. And I'm going to do that for you guys either tonight or tomorrow. It's unclear. But I got a really smart accumulation of evidence from somebody on Reddit that's been sleuthing on this case that I thought was really smart and worth going through. But we'll do that. Reynolds knew about the smear campaign narrative was false or acted with reckless disregard. Reynolds got a hold of communications between the Wayfarer parties from Stephanie Jones that disproved the claim. That's really important. Disproved the claim the Wayfarer parties had orchestrated a smear campaign. Given that they had these materials, Reynolds, Lively, Sloan either knew the narrative they later publicized was false, or at best disregarded the evidence. It also would have been clear to Reynolds, who owns a marketing company, by the way, that the cause of Lively's bad press was her decision to hawk liquor and hair care products while promoting a film about domestic violence. I don't remember that being in the pleadings, and to the extent that it wasn't, and I don't have a photographic memory of these pleadings, maybe now Friedman is the one who's bringing in extrinsic evidence to support his opposition to this 12v6. And forgive me, I just don't, if he did bring that up prior to this, I just don't remember it. Maybe he did, I don't know. I know I've heard this before, I just don't know where. There's so many moving parts with this case. The notion that the backlash was caused by an untraceable smear campaign is so inherently improbable that only a reckless person would have put the claim in circulation. That is an issue for trial, which is, I don't think he would argue with that. Of course it is. Finally, the FAC satisfied the Wayfarer parties' pleading burden under an actual malice standard. It is important to note that 6 of the 7 Wayfarer parties are not public figures. The mere involvement of a person in a matter which the media deem to be of interest to the public does not, in and of itself, require that such a person become a public figure for the purpose of a subsequent libel action. Because the FAC satisfies the burden of actual malice as to all the Wayfarer parties, it is unnecessary to analyze the lesser standards. Agreed. And thank you for saving us some time. The Wayfarer parties have adequately pled claim of civil extortion, as Reynolds concedes. California recognizes a claim for civil extortion. Reynolds claims the tort is limited only to extorting money through threats of prosecution, but points to no authority that California courts so limit the claim. Under California law, the exact contours of this common law tort are not so strictly defined. Civil extortion claims are based on the law of criminal extortion. Courts applying California law hold a civil extortion claim will not lie only where obtaining money was the aim. In other words, just because you didn't get any money or that wasn't the aim doesn't mean that you're off the hook. If the aim was an accumulation of power or to take over the film or to ruin somebody's reputation, well, we're going to listen to that. That's all that means. Nor must a threaten prosecution to be actionable. Ryan did kind of argue that. Ryan Reynolds claims the tort only to extorting money through threats of prosecution, but points to no authority. Yeah, that's what he said. That's where he said that. I know I saw it before. The court is unaware of any case holding that there must be a threat of litigation in order to state a plausible claim for civil extortion under Twombly and Iqbal. And by the way, folks, I'm not sure when I'm going to finish up with this stream. I got a little ways to go, but at the conclusion of this video, I'm going to push you guys over to Ask Two Lawyers so you'll hang out with them for a little bit when I'm finished with this. Let me just make sure that here we go. Oh, well, maybe I can't do it like that then. Well, I'll kick you guys over there anyway. All right, let me continue with this before I get too far out. Here we go. Court is unaware of any case. Okay, same thing. California law prescribes extortion notwithstanding that the defendant ultimately obtained no money or property by means of his extortionate threats. Here the Wayfarer Parties have alleged the facts sufficient to state a claim for civil extortion based at least on the demand by Reynolds and Lively that the Wayfarer Parties issue a self-destructive statement taking blame for Lively's press woes, or else the gloves would come off and they would attack Wayfarer in the press. Read that again. The Wayfarer Parties have alleged facts state a claim based at least on the demand by Reynolds and Lively that the Wayfarer Parties issue a self-destructive statement taking blame for Lively's press woes, or else the gloves would come off and they would attack Wayfarer in the press. That's pretty effing damning evidence of an extortionary threat. And all of these issues, Judge Lyman is going to look at he's going to say that all of these issues are triable facts for the jury to decide. So he's not dismissing Jack, in case you were wondering. The FAC thus alleged that Reynolds and Lively expressly demanded consideration, and if the Wayfarer Parties refused, threatened their business or property interest to the extent that the Wayfarer Parties' factual allegations do not suffice, the court should grant leave to amend. In other words, if we haven't pled enough, I promise you we can fix it. The FAC pleads a claim for false light, invasion of privacy. So the law of California must apply to the Wayfarer Parties' claim for false light, invasion of privacy. Under California law, false light claim is not duplicative of the defamation claim. The sole case that Reynolds cites for this proposition is in a posit. It's Brooks versus Physicians Clinical Laboratory, a 2000 case. The court noted that the defamation of false light claims were based on the same single statement. Both the false light claim and the libel claim are based on the same alleged defamatory statement. Here, by contrast, the Wayfarer Parties allege not only that Reynolds conspired to defame them by means of false and harmful statements, but also that Reynolds and others conspired to place the Wayfarer Parties in a false light by means of false statements and distorting factual statements beyond recognition into falsehoods. They literally did that in their 12v6 motion. They literally took material that Baldoni had published years ago and tried to spin that and distort it into evidence that formed the basis of why Reynolds was of the opinion that Baldoni is a sexual predator. Reynolds is in a lot of trouble here. If this gets to trial, they're going to grill his ass. All right. California law has long recognized that the torts of false light and defamation are distinct claims with related but separate elements. California courts do not dismiss false light claims as merely duplicative of defamation claims, but determine whether a false light claim stands or falls based on whether it meets the same requirements of the defamation cause of action. I'm trying to skip over stuff that is kind of redundant so as to not put you all to sleep. The court finds that the plaintiff's false light claim survives the pleading stage because it is based on the same statements as the defamation claim, which claim is supported by sufficient factual allegations. Quoting a case, any overlap in the claims for false light and defamation is not a reason to dismiss the false light claim. It just means the claims will likely rise or fall together before the jury. Just because they're similar doesn't mean you dismiss. They both stand on their own merits. And if you disprove one, you likely disprove the other. But that's for the jury to decide. Not grounds for dismissal. To the extent that there exist any defects in the Wayfarer Parties' false light claim, the defects can readily be cured by amendment. They've been saying this a lot. Courts applying California law readily grant leave to amend claims for false lights, and they do. It's true. Of course, because the actions of Reynolds and his co-conspirators were carefully concealed, this is really important, less particularity is required when it appears that defendant has superior knowledge of the facts, so long as the pleading gives notice of the issue sufficient to enable the preparation of defense. In other words, when I did my video for Reynolds 12v6, one of the things that I said was, they might not have all of the who, what, when, where, or why, because they haven't even started discovery. What they have is, they have what they know, they pled what they knew, and they have suggested that Reynolds was involved in a plan with Lively and her PR team to do bad things to Justin. How, what, when, where, why, and with whom is, we're in the process of figuring it out. But the fact that at the very beginning of the pleadings that was the case, it doesn't mean that we're not going to be able to cure it through discovery. Look, it could be the case that we go through complete discovery and figure out that, no, well, it wasn't a conspiracy after all. It was just a big misunderstanding. And then they just agreed to dismiss. That could happen. But the other thing could happen is that their suspicions pled, their allegations pled on information and belief could be corroborated through further discovery, which would give rise to an amended complaint, either responding to it or being prompted by a 12v6 motion, or perhaps on their own motion to amend. They might find out additional facts and ask to amend the complaint themselves because they want to add additional causes of action that they didn't contemplate before but are obvious now after getting more information. So, I think I read this right. Less particularity is required when it appears that defendant has superior knowledge, so long as the pleading gives notice of the issue sufficient. They have notice. They know everybody knows what everybody is talking about. The FAC adequately pleads tortious interference claims against Reynolds. I'm not going to go over a lot of this because a lot of it is just redundant. The way that they were interfering is with these defamatory, false lights, conspiracy, extortionist claims, right? And because those things are true, then we have to also consider what they were directly interfering with, which would be these business torts. The FAC alleges that Reynolds approached Baldoni's agency, namely an executive at WME, and expressed his deep disdain for Baldoni, suggesting the agency was working with a sexual predator, as we've already kind of discussed. And they're going to go and rehash all of that here. Finally, FAC alleges Reynolds' threats and demands induced WME to cease performing under his contract with the Wayfarer Parties because talent agencies are typically paid by commission as a percentage of their clients' earnings. It can be fairly inferred that these allegations that WME would fear its own economic harm from attacks on Baldoni and Wayfarer and would be coerced to drop Baldoni and Wayfarer to maintain more profitable relationships with much bigger stars such as Reynolds and Lively, who would generate larger commissions. In other words, they're rigging the game for their own personal financial gain later on down the road. They might not get all the money right now, but they're going to get it like next year when WME doesn't want to work with Baldoni because he's a sexual predator, and Reynolds and Lively are much bigger stars. That's been their narrative really since the start of 2024, December 23, whenever all that other stuff happened. While it is true, as discussed below, that proper categorization of the tortious interference claim may depend on fact issues that cannot yet be resolved without discovery, this does not warrant dismissal with prejudice. Pleading in the alternative is well-established practice, particularly where relevant facts may exist that are not readily ascertainable by defendants. You guys get the gist. California's tortious interference law applies. Reynolds suggests that New York choice of law principles dictate applications, and they're saying, well, even if that's true, of New York law to the tortious interference claim, because that is where the tort occurred. Reynolds, a New York resident, makes the unsworn claim on his unverified complaint in briefing that he was physically present in New York when he made all of the alleged statements to WME. But this argument incorrectly presumes that the place where defendants' conduct occurred necessarily defines the place where tortious interference occurs. Under New York law, we kind of went over this at the beginning, but under New York law, that does not follow. Courts applying New York choice of law principles look to the plaintiff's location or to the place where the contracts of prospective relationships existed, California. The Wayfarer Parties contract with WME was based in California, as were the prospective economic advantages they reasonably anticipated from the contracts with WME. California has the greatest interest to the extent a conflict exists. California law applies. That is an argument, to me, that is the most, there's more meat on that bone than anything else for Judge Lyman to determine. So we'll see where he goes with that. In my opinion, I feel like this case should be litigated in California. I kind of agree with Friedman. Not kind of, I do agree with Friedman in that, look, they went to the CRD to file a complaint. They're the ones claiming that California law controls. You can't just pick and choose and cherry pick. Obviously, they're seeking protections under California for their own purposes. They can't disavow themselves of California law because it's advantageous for them to do so. The hell with all that. California's the venue. That's going to be the argument. Reynolds contends that under New York law, tortious interference is duplicative. First, Reynolds ignores the fact that courts applying California law do not treat such claims as duplicative. Second, where a plaintiff plausibly alleges that its economic harm was not directly and solely caused by generalized damage to reputation, courts applying the New York law will let the defamation and tortious interference claims to coexist. A claim does not sound in defamation rather than tortious interference merely because the complaint contains allegations of defamation. The FAC states a claim for intentional interference with contract, and it's kind of the same thing. Reynolds claims that the elements under California and New York law are the same. Reynolds then materially relies on this misleading with these words, this misleading misstatement of the law to argue, without citation to authority, cessation of performance is not the same thing as a breach of contract. Yeah, it effing is. In some cases, I guess it depends, right? But causing a third party to cease performance is the same thing as disruption of a contractual relationship, which meets the California standard based on this 98 case. One who intentionally and improperly interferes with the performance of a contract between another and a third person by inducing or otherwise causing the third person not to perform the contract is subject to liability to the other for the pecuniary loss resulting to the other from the failure of the third party. You guys get the point. Reynolds' other arguments that the specific details of the contracts with WME are not sufficiently described, and that Reynolds' knowledge of those contracts is alleged only in general terms, are easily curable issues which the Wayfarer parties should be permitted to address by repleading. So Friedman is kind of acknowledging, look, I know that you're going to want me to amend some stuff. Just know that if you're wondering, we can fix whatever there is. Tell us to amend it, and we'll amend it, and then some. So they're not afraid of an amendment. I think they know that they're going to have to amend it anyway, and they might have planned all along to have that they were going to need to amend this at some point anyway with additional information. Reynolds himself is alleged to be a client of WME, and the context of an industry in which WME represents many prominent film actors and directors on identical or nearly identical terms by procuring engagements for them and receiving commissions as a percentage of earnings give rise to the influence that Reynolds, one of the most successful actors, understands the contractual terms by which talent agencies, and specifically WME, are bound. Further, contrary to Reynolds' disingenuous argument, the FAC clearly identifies Baldoni and Wayfarer as the Wayfarer parties, who were represented by WME. They continue, even if WME's contracts with Wayfarer parties were terminable at will, they were undisputedly disrupted. California Supreme Court held that to state a claim for tortious interference with a contract terminable at will, a plaintiff must plead an independently wrongful act. An act is independently wrongful if it is unlawful. That is, if it is prescribed by some constitutional, statutory, regulatory, common law, or other determinable legal standard. The FAC clearly alleges an independently wrongful act by Reynolds, and we went over those ad nauseum. Reynolds attempts to downplay his defamatory statements that Baldoni was a sexual predator and that the WME was working with a sexual predator as merely insulting and therefore not wrongful means. As discussed above, his statements plainly were defamation per se. So they're repeating themselves. Alternatively, the FAC states a claim for intentional interference with prospective economic advantage, and this is just a lot of kind of the same stuff. I'm not going to go through all of this. But this part I thought was interesting. Reynolds attempts to invoke the privilege of economic self-interest, an exception to international interference with prospective economic advantage, by suggesting that his alleged motive to seize control of the film production proves he did not act solely out of malice. Not really how that works. That phrase, which reads in its entirety, the defendant acted solely out of malice, or used dishonest, unfair, or improper means, is not even a requirement of California law. Reynolds does not claim that he and Baldoni were actors competing for a role and that his conduct was intended to cause WME to procure the opportunity for him instead of Baldoni. His defamatory statements and threats were intended to accomplish what they in fact did accomplish, that WME would drop the Wayfarer parties from representation. Alternatively, the FAC states a claim for negligent interference prospective economic advantage. California does not require a plaintiff to plead a duty of care. However, although the First Amendment complaint does not directly address this legal issue, there are facts pled, so they're kind of acknowledging that they fucked up with this issue. And they're saying that you could have inferred certain things through other parts of the complaint. Although the FAC does not directly address this legal issue. There are facts pled which may give rise to a duty of care, such as the fact that Reynolds' promotion company, Maximum Effort, was hired to promote the film. As an agent, Reynolds may be under a duty not to recklessly damage the film's director, lead actor, and studio in the eyes of the public or their talent agency. And under California law, a duty of care may arise through statute or by contract, or may be premised upon the general character of the activity in which the defendant engaged, the relationship between the parties, or even the interdependent nature of human society. Knew that was an older case. The agreement between plaintiffs and defendant created a duty of care. Because a duty of care may arise here, at minimum, Wayfarer Parties should be permitted an opportunity to replead the existence of a duty of care if you really want us to. So they're kind of, yeah, we didn't plead it, but still, we don't really have to. But if we had to, then this is how we would do it. But just let us replead it. It's basically what they're saying. Reynolds is liable for his direct actions as well as by conspiracy. The Wayfarer Parties have not brought a standalone claim for civil conspiracy, as conspiracy is instead a legal theory by which the parties may be made jointly liable for an underlying wrong. Conspiracy is not a cause of action, but a legal doctrine that imposes liability on persons who, although not actually committing a tort themselves, share with the immediate tortfeasors a common plan or design in its perpetration. The burden of proving, let alone pleading tort liability on a theory of conspiracy is not high. It is axiomatic that the proof required to show that a defendant knowingly associated with an existing conspiracy need not be overwhelming. Indeed, participation in the conspiracy can be shown entirely through circumstantial evidence, which is distinct from having to show. You have to plead a conspiracy or prove a conspiracy through clear and convincing evidence. But once you do that, it's not that difficult to attach people to the conspiracy. The bar is not really that high to prove that you had knowledge of a thing and you went along with something, is what they're stating right here. The Wayfarer Parties have pled ample allegations and connections and stuff. We don't need to go through all that stuff. They talk about attorney fees not being available to Reynolds under Second Circuit law because he's claiming them for anti-SLAPP provisions in New York or California. But this is a federal case. The Second Circuit does not permit the application of state anti-SLAPP laws that conflict with the federal rules of civil procedure. Reynolds does not argue for the application of California's anti-SLAPP law, which, as the Second Circuit has held, is inapplicable in federal court because it conflicts with Rules 12 and 56. The Second Circuit has not yet directly addressed the question of whether New York's anti-SLAPP law applies in federal courts. Still, federal district courts in the Second Circuit, including courts in this district, overwhelmingly agree that the holding of law liberty precludes the application in federal court of New York's anti-SLAPP law, which, like California's, creates a special procedure mechanism through which defendants can invoke the anti-SLAPP law in a motion to dismiss. Continuing with this stuff, Rule 11 permits a court to impose sanctions only after the adverse party has been given notice and a reasonable opportunity to respond and to withdraw or correct the challenge proper. I'm not going to go over all this stuff, but the gist of the argument is they're not entitled to anti-SLAPP attorney fees because it's a federal case. That's really it. For a lot of reasons, and then they're requesting for their denial. So that was the gist of the complaint. Well, that was the complaint. That was the opposition, folks. That's all I got to share with you for Reynolds' opposition. Later tonight, I'm going to be diving into, if there's nothing else to report, because I'm expecting some other oppositions to come down in this Lively case. But I was going to start examining or start tying together some of the dots with the help of this Redditor that is pieced together just very brilliantly a timeline of the text messages and built a theory of conspiracy based on the timeline of stuff that's already in the pleadings, and we don't even have all the information yet. And so, but I thought it was worth going over. Folks, I love you all. I tried to redirect to Ask Two Lawyers. They're live right now, I think. I think they're live right now. But if you are unaware, go check them out. They're going to be talking about the exact same thing, and tell them that I sent you. I love you, folks. We will see you guys next time. Bye-bye.